Okay, good afternoon, everyone. I'm Christina Ramirez, and I am your host today at the Surrogate session with Surrogate Heather Darling and attorney John Vitale. Today's webinar topic is in recognition of National Make a Will Month with the topic, Simple Steps to Make Your Will. Before we start, a couple of housekeeping items. All participants are muted, but you have the ability to ask questions throughout the program by typing them in. The panelists look forward to answering your questions after their presentation. You should see the Q&A on the right-hand side of your screen, which you can type in throughout the program. Now, let me introduce to you our surrogate, Heather Darling. She's an accomplished attorney. The surrogate received her bachelor's degree from NYU in finance and international business and earned her law degree, Juris Doctor, from the Seton Hall School of Law. Heather is a former Morris County freeholder and served as deputy of the board. She was elected in 2019 as the first woman surrogate in Morris County, and she took office in January of 2020. With her today is John Vitale, Esquire. John has over 42 years of significant, diversified experience in multiple disciplines of law. He has many years of experience in wills, estate planning, trusts, and asset protection, just to name a few. He has a Juris Doctor from Seton Hall University and a BA also from Seton Hall in political science. As a reminder, please use your Q&A box to send in your questions. And I'm now going to turn the program over to Surrogate Darling.
Welcome, everyone. Thank you for joining us during your lunch hour for our presentation. John, thank you for joining me today. It's a pleasure and privilege to have you here.
Thank you, Judge.
So why are we doing this? August is National Make a Will Month, and I know some of you are aware that we've done this presentation on making a will and how to make a will previously, but this is a very significant topic, and it's something that a lot of people just don't seem to want to do for one reason or another. They kind of feel like it's a fatalistic type act. So this is part of our ongoing educational series designed to educate people about issues and procedures here in the surrogate's court. So decisions about your wishes are best made when you're lucid mentally, when you're healthy, when you don't have stress and pressure. Those things come into play and you start getting clouded in your judgment. So we strongly recommend that you make a will sooner than later, and that you do so when it's not a desperate time. Writing a will doesn't have to be difficult, and today John and I will share with you some key components about what you should know. So first and foremost, what is a will? A will is a legal document that takes effect only upon your death, and it sets forth your wishes. Your wishes include where you want your stuff, your property, to go, to whom, so the beneficiaries, and the individual or individuals that will be your executors that will divide it among these people. Also, if you have minor children, it's useful to list a guardian under your will. So in the event of your death at the time that your children are still minors, you have that guardian in there that you know will be the right person to take care of your kids. Now, a will can be brief and still be valid. It doesn't have to be a big complex document. So what you really need is to make sure your intent is carried out. This is why you need a will. And it makes clear, like I said, those intentions upon your death. And it tells your executor exactly where you want things to go. And the death of a loved one being a very stressful time, you don't want a family member or someone close to you trying to figure this out and trying to decide who would want what, deciding where you would want things to go, having family members fighting over this, or possibly passing your assets to people under a different set of laws that John will get into in a little while. So who is involved in preparing a will? We highly recommend that you have an attorney who's experienced in estate matters to be involved and draft your will for you. Of course, the testator is the individual that is writing the will. That would be, if I sat down and wrote a will today, I would be the testator in that will. You're going to want to have 2 witnesses, and also you should let the executor know And you should ask them, are you willing to do this? Because it's not a small job. So John, it's probably a good time to talk about some pitfalls of not having a will and how your assets would pass in that event.
Well, as an attorney and through my practice, I'm sure you have seen this in your office here, in your court. What happens if you do not have a will? In absence of will, one dies intestate. What that means is your wishes are now controlled by the statute of intestacy, which comes into play. And this is especially substantial to you if you have assets that maybe you want to give to one particular person and not for another person to share in. And what happens when you die intestate, you have to be appointed by the surrogate court as the administrator. And that usually includes spending an extra couple of dollars, and sometimes it's more than a couple of dollars. You have to obtain a surety bond, which is required when you die intestate. An administrator is appointed before the administrator can collect any assets, pay debts, and make distributions of the estate. And then what happens is the administrator the hands are tied by him or her by the intestate law, and the intestate law runs according to immediate family and how your property may go to distant relatives or even the state. When I say to the state, that means if one dies intestate without relatives, it cheats to the state. It goes to the state treasury, and that becomes a little complicated when an heir at law may surface, and they have to then try to retrieve your estate assets from the division of taxation.
So, John, when we talk about that property acceding to the state, of course, that goes into unclaimed property, and an individual can then go and access that property once they come through the surrogate's court. And in your experience as a practitioner in this court, what do you find as far as appointing an administrator? Sometimes it's a very simple process, and other times you end up in court trying to hash out who's going to be the administrator in the state, correct?
Well, that's correct. And you have to notify every heir at law that may have a right to be the administrator. Say if you have a distant relative that is lineal heir that may be able to become administrator, and you can't find them, you might have to do a publication in the paper. So it becomes expensive when an estate has to be administrator according to the intestate laws.
So John and I are going to go over some keywords for people to understand. Now, the testator, as I said, if I were to write a will today, I would be the testator. It is the person whose will it is. Now, different types of wills include a standard will, which is one that is written and signed by the testator, witnessed by two individuals, and it has with it an attestation clause that declares it as the last will and testament of the testator. Now, a self-proving will is the same as a standard will, except it's notarized, and it's notarized saying that the two witnesses, the testator and the notary, all signed in the presence of one another. And what that does is it verifies in multiple ways that that document is a valid document. There's a presumption of validity that goes with this document. So when a self-proving will comes to my office, we don't need to have witnesses appear. We don't need anything to go to court. We don't need to take any testimony on anything. And it's the simplest procedure that you could possibly have in this office. And then you have a holographic will. And a holographic will is written in the hand of the testator. It is not witnessed. And typically it's admitted to probate only after an appearance in the superior court in the manner prescribed by the rules of the state of New Jersey. And that's typically, my airplane is going down, I have a cocktail napkin in front of me, I write a will quickly on that and hope that somebody finds it with my signature on. So it's not reliable. It's not something that we recommend doing if you have time to plan, but when you've got nothing else that you can possibly do in the middle of the woods on a hiking trip or something, it's better than not. So in order to have a valid will, you need the signature of the testator, you need a date, you need two witnesses, and you need to specify that this will is the last will and testament of the testator and revoking all prior wills. Also, a will, in order to be valid, has to be written when the person is of sound mind. So the date on the will would inform your relatives as to such, or your close friends, anyone that may be an executor or executrix. It would inform them as to whether or not you were of sound mind at that time, because presumably they would know your state. And were you in a state of substantial decline for several years and happen to write a new will today, well, that may be subject to undue influence. So, John, would you like to talk to the viewers about executor, executrix, and some other terms?
Yeah, a person named in the will as a executor, executrix is to carry out the wishes and the intention of the testator of the will. And when you name an executor, executrix, you should at least be naming somebody that you know will represent the wishes that you to be carried out in the event of your death. Executor, executrix has to marshal the assets of the estate, as well as also marshal the debts of the estate. And pursuant to the obligations, they have to take every effort to pay the debts, and also to notify the beneficiaries that a will has been submitted for probate. And if the beneficiaries wish to get a copy of that will, it's their obligation to provide the beneficiaries with a copy of that will. In addition, the executor or executrix sometimes has to go above and beyond that. If there's a challenge to the will, they have to defend the intent of the testator at that time.
What about trustee, John?
Well, a trustee is can usually be the executor or executrix, and a trustee is a person that's holding property in trust for another person. Example, that would be a beneficiary. Say that the testator doesn't want the beneficiary to inherit all the money at one time. A trust may be established with inside the will, and it's up to the trustee to administer the wishes of the testator according to the language in that portion of the will set forth as the trust.
And that would be called a testamentary trust.
That'd be a
correct?
testamentary trust, a little bit, different than a simple will, but it's also could be one or two paragraphs, and it becomes very important in the event that a testator believes that this beneficiary may need some oversight in the asset that is left to them.
And another time, I think it's a good time to bring it up, that might become pertinent, is if you have children from a first marriage and you're in a second marriage, you want to leave assets to your spouse, but ultimately have them go to your children rather than passing them in total to your spouse, so that they then become the owner and may divert them to their own children or others, and not to your children in the event that relationship is not necessarily let's say first rate between the individuals involved. So John, a beneficiary, you want to go over what that is?
Well, a beneficiary is a named person in the will that has been basically gifted money or an asset of the testator or the testatrix, and that becomes their property as long as the estate can administrate that property to them, that being that the property is still, one, in existence, and two, the estate has the assets and the ability to fulfill the wishes of the testator to the beneficiary. But the beneficiary has rights under the will because they're an interested party.
John, under the laws of intestacy, could there also be a beneficiary without a will?
Oh, yes, yes. It would go by lineal heir of your brothers, your sisters. If one of your brothers or sisters or siblings have passed, then their children may take in their place.
So the next thing is will challenges. A caveat can be filed, and that is a formal notice that is given to our office to prevent the proving of a will or the granting of letters of administration of an estate. And what happens is once that caveat is filed, as long as that person who's filed it has standing, the matter has to go to a court to be adjudicated in the Superior Court before anything can move forward with probate, before any assets can be distributed, before an executor or an administrator can actually be appointed. So while you, the testator, in your will would name your executor, we actually appoint them in our office according to the terms of your will or the laws of intestacy. So they don't actually have authority to act until they receive letters testamentary or letters of administration from our office. And a caveat would forestall that from taking place and disable them from dispersing assets, even if they were named under the will. John, let's talk about what should be included in a will.
Well, what you should have in your will is the property that you own and who you wish it to go to. Any specific bequest you have, say, a Schedule A, if you have certain jewelry, paintings, a car that you value, and what happens to the items of property that you haven't mentioned, that goes into what we call your residuary estate. And of course, as we discussed before, executor or executrix should be named, and that should be a person that you think will uphold your wishes. And also, when I draft, I'm talking about a simple will now, I put in a funeral director pursuant to the statute of how you wish your remains to be taken care of once you have left this earth. And of course, as the judge said before, you want to make sure that the will is properly executed, because failure to have a proper executed will, as we indicated, would bring it to an ending that you might not want to have, and that be judged by a Superior Court judge whether the execution of the will was properly done according to the statute and law.
Now, John, you mentioned the funeral arrangements be included in your will. And in our first edition of this video, my deputy and I discussed this. And of course, it's only valid if it's in the will, your funeral arrangements or your last wishes. But what's interesting is, as you know, a will cannot be probated for a minimum of 10 days after the death of the testator. What typically happens is, in the meantime, the funeral takes place, right? The funeral takes place, the body's disposed of, and now, what if you find out that the last wishes of the testator were written in the will and they were contrary to the way that the body was disposed of because people didn't know? So what I recommend is also you should have with your will, your power of attorney, you should have your living will. And in your living will, which presumably would go with you to the hospital, they would then see, because they're in possession of your remains after your last illness, they would then see exactly what your wishes were. They would know who you wanted to pick up your remains, as in which funeral home, and how you would want them to be disposed of, as well as if you already had a plot picked out, if you had a plot paid for. These things are very pertinent and should be known in advance of probating your will. So again, not valid under the living will, but highly recommended to have them in both places, because then the will backs it up with the validity.
Well, Judge, I'm a proponent of that. I think the funeral agent, right, you're correct. It's not valid when it's in the living will, but it does give a roadmap. I could give you an example that happened in Morris County here that I was involved in. Going back to what you said before about maybe a second marriage. We did have a second marriage, and what occurred here was the daughter from the first marriage always said her dad wanted to be buried. The second wife said, no, I'm going to have him cremated. So what the daughter did was file a caveat, just as you explained before. Came down to the courthouse. The wife tried to probate the will. Caveat was filed within the 10-day period. And it unfortunately, it had to go up to a Superior Court judge. And after much litigation, it was resolved. But I think that's a very good idea to have it in the living will, your medical directive, because it does give a roadmap of where the testator or testatrix wants the remains to be finally rested.
Thanks, John. One other thing would be minor children, of course, to have in the will, and how would you address that?
Well, the minor children you would do by having a guardianship appointed for the person within your will, and that person would have to come to the surrogate's office and be qualified as the guardian. Usually the guardian would be the executor or the executrix of the will also, or it could be somebody else who you think is closely to that minor children or child, and that would be the person that you'd probably appoint as the guardian. They would then become the guardian of the assets that is left to the minor children at that time. And backing up one other thing, Judge, we talked about beneficiaries and trust. A trust doesn't have to be just for a person under 18. Some wills that we draft, the testator says that the assets shall not be turned over to the beneficiary until they're a certain age. It could be 23, 30, 35, because they have some concerns.
And tiered as well, potentially.
And
so
tiered.
You get that first taste and burn through it.
Correct.
By the time you get a second taste, hopefully you've worked for a few years and figured out you don't want to burn through it a second time.
Right.
So you mentioned, John, assets, and you mentioned an Exhibit A. In lieu of Exhibit A, there's also something referred to as a codicil, which is utilized often to include assets that are typically transferred. So let's say somebody's a collector of art or vehicles or something like that. They may draft a codicil that references changes in these collections as they take place over the years. Now, a codicil is interesting because it makes changes to a person's will. It can change everything from executors, beneficiaries, assets, and whatnot. But a lot of things change between the time that a person goes from drafting a will because they had a child and the child's 6 months old, they want to make sure the child's taken care of, to the time that a person may die in their 70s, 80s, 90s, hundreds. And that being the case, a codicil or multiple codicils can become very messy. So what I recommend is, unless you're utilizing the codicil for purposes of nothing other than these assets, and even in that case, it hasn't been too many changes and transfers. Other than that, I recommend revising your will because it becomes confusing. Now, if you do a codicil, it should always reference back to the original will. It should reference it by date, and it should also be witnessed in the same fashion. It should be signed by the testator. It should be witnessed by 2 witnesses, and it should also be notarized, all done at the same time. Because that way we know that this codicil actually revises a will that is the current will, as opposed to a will that has been invalidated by future wills. And I think, John, you brought that up earlier when you and I were discussing today's presentation, was that when you write a will, you make sure that that will indicates that this will revokes all prior wills, because you want to make sure that nobody can present an outdated will for their own personal gain when they don't want a current will to be probated.
That's correct. Every will should have that in the beginning paragraph, if that this will revokes any and all prior wills that I have. In the old days, they used to actually rip up the old wills, but that's no longer. So you should definitely have that language in there.
Now we have shredders.
Now we have shredders, correct.
So To conclude and to wrap this up as far as our presentation before we start the Q&A, which I know is always the part that the people like best because you can ask what you want to know. So how do we draft a will? How do you actually get started? Three basic things. You gather, right? You gather your assets, you put together a list of assets. And we have just now come up with this booklet, which is called the Personal Record. It is available by contacting surrogate@co.morris.nj.us, or if you don't want a hard copy, although we do recommend getting a hard copy and leaving it with your estate planning documents, you can also go to surrogate@co.morris.nj.us and morrissurrogate.com, and you can download the PDF version of it. Just as if you watch this today and you have questions about something you've heard, you can visit www.morris.surrogate.com, and you will find today's presentation listed there, as well as other presentations that we've done that are similar in nature on different topics. So the next thing you want to do is decide. You want to decide who your beneficiaries are and who your executor or executrix will be. And you always want to choose successors. What if something happens to the person that's going to be your executor? Who's going to be next? And then who's going to be next? Always go younger, always go smart, and whenever possible, go local. And finally, do you need or want an attorney? And I think it's very difficult to not use an attorney for this. When you look at the cost and you look at the value of your assets and what could go wrong if you don't pay a few $100s to have an attorney draft up this document for you that's so important, and your estate is worth 100,000 or a million or 100 million, you're being penny wise and dollar foolish. So thanks to everyone who was here today to listen to our presentation. I hope that it's been informative, and the exercise of preparing a will hopefully has been simplified a little bit for you from today's presentation. And Christina, I see we've had a number of questions come in, so at this point, I'm going to flip it back to you.
Okay. So let's start with the first one that came in. How do you address online accounts and passwords in the will? For instance, what language to use so an executor can access online accounts? Also, how does an executor access electronic accounts if he or she does not have the passwords?
I'm going to jump in on that one, John, if you don't mind. What we've done with this personal record that we have is we've actually included a place to list your passwords, your online accounts, so that somebody can get in there. Let's say you have a social media account that somebody wants to take down. A family or a relative wants to take it down, or a good friend, because for some reason people are posting there posthumously and it's just giving you a level of discomfort. That's in there. For your bank account passwords, that's in there. You can put anything and everything that you want in that book that you feel would be pertinent for someone to know. And we think that that's critical information. So that's a great question.
Okay. What is the process if I have a will for myself that is out of date? Can I go to a different attorney?
Yes, you could go to any attorney of your choice to have that will not updated, but write a new will with some of the instructions that we gave previous as to what the will should contain.
Now, one addition that I'd like to make to that is, John, I'm not sure if you do this, but I know that some attorneys, if you've prepared a will for them, for a person, and they go back to that same attorney, they'll often have that document saved on their server in paper form, and they'll be willing, or in Word form, and they'll be willing to make edits for a lesser fee than preparing the entire document, as long as those edits are not very significant. And it's sort of a benefit to you if you go back to the person that had it. But if that's the case, you should check in advance, because if it's many years ago, they may not have it on the server anymore. And it may cost you the full amount in any event.
Well, that's correct. And if they come back to me and I've done a prior will for them, I usually reference that in the new will, saying that this hereby revokes that's the other will by a certain date and year.
Okay, when a will is updated, can a previous will be destroyed?
Well, I say that before, it should be destroyed, but you certainly should make reference to it if you know the date and the year that will was executed.
And also, when you're saying update it, if you mean by codicil, no, you don't destroy the will. If you mean by a new will, then yes, you would destroy it.
And just talking about codicils, I'm not a big fan of a codicil, especially when it's going to change an executor or executrix or move around some real assets. I would say you should just write a new will at that point.
So a point of clarification on that. So when you're writing a new will, you've had one previously, should you say something that this updates all prior wills in the new will? Should that statement, is that needed?
You should say it revokes all prior wills.
Okay,
It's a revocation you want.
all right. So when one leaves assets, can you leave a percentage of total money assets to individuals, or do you need to determine an exact dollar amount?
No, you're free. You're free to cut up your assets in any form or percentage that you wish.
I recommend that, because what happens is people will come in and say the first X amount to this person and the next X amount to that person. And by the time that the person dies, if they live to be 100, the first person is the only person that's going to inherit, even though that wasn't their intent, because the first person is going to receive basically the bulk of the value of the residuary estate, and there will be nothing left for the other beneficiaries.
So it's recommended that you do a percentage rather than a hard dollar amount.
I would recommend it. And oftentimes what people do is they want to make sure they include, let's say, a nephew. So they'll say the first 10,000 to my nephew Phil, and then everything is to be divided equally between my 3 kids. Well, if you do it that way, Phil gets money before your kids. And if all you die with is $10,000 to your name, Phil gets it all and your kids get none, even though your intent was to give Phil a little something, because your estate was $20 million when you drafted it, and the bulk of that was going to your 3 kids.
Okay. We have a number of questions, so just give me 1 second, because they're coming in 2 areas. What is the process if I have a will for myself that is out of date? Can I go to we already answered that one. Apologize. Difference between an executor and an administrator.
Well, executor or executrix is named in a will. Administrator, administratrix, that is by intestate. That's when you have passed and left this earth without a will. So now you're in an intestate statute situation.
And as an addition to that, if you have a will and you leave an executor under the will, and that executor either predeceases you or is not fit to be the executor or executrix, and let's say the same thing happens with the successor. Let's say that they both predecease you. So now you have a valid will, but there's no executor named under that will that's able to serve. This in the same regard, we would appoint an administrator, CTA, in this office, which is a form of administration that's done, but it still references back to the will. So the disposition of assets would not follow the law of intestacy, it would follow the will, but the administrator would be appointed by this office because there was no executor left under the will.
Can either of you provide some guidance for living will issues, examples of handling different end-of-life health issues and how to list those things in a living will?
Not in today's event, only because we would have to visit the entire subject to make that make sense to everyone watching, and it wouldn't be fair for those who signed on. But we do actually have a living will video that was done previously. And we've done several presentations to that effect as well. So if anyone has specific suggestions or questions on that, we'll be happy to entertain doing that another day. But at this time, no.
Okay. Is it the norm to pay an executor?
There's statutory fees, John, if you want to go over that,
It's a statutory, it's just 5% to the first 200,000, then 3.5 after that, and it drops down again. And there's also a fee you can make on any type of interest that you make on money that's left on in the assets. But it's up to the executor or executrix whether they want to take their fee. Not too many wills say the executor shall serve without commission. That's what it is. It's a commission. A lot of wills will say that the executor, executrix shall serve without bond. So that saves the estate money. But I would say usually the executor, executrix will take their commission. I say that they're entitled to it because being an executor, executrix, it's a lot of work sometimes. It's a lot of decisions you have to make that that maybe they're not in the best interest of the beneficiary, but it's in the best interest of the estate based upon the assets versus the debts.
John, you mentioned bond. In what circumstance would someone have to be bonded if they came into the office?
As I said before, if you're an administrator appointed without a will, sometimes if the trust says there should be some type of bond, or the guardian law says there should some type of bond, but usually it's usually when it's an intestate proceeding.
Does a standard will have to be signed in the presence of two witnesses?
It always should be. It doesn't have to be. It's not the same as the self-proving.
And what is the typical cost of having an attorney complete a self-proving will?
Well, it would depend upon the estate assets and how the testator, he or she wants them to be distributed. But I would say usually you're somewhere in the neighborhood of 500 to 750.
Does a will supersede beneficiaries designated for an account such as a mutual funds beneficiary?
Designated beneficiary accounts pass outside the will. They pass outside probate. So if you were to have, let's say, an annuity that had a designated beneficiary, you were to have a bank account that had a designated beneficiary or certain rights of survivorship, then that passes outside of probate.
It passes outside of probate, but the executor, executrix is still charged with gathering that asset for, say, inheritance tax purposes if it's not a Class A beneficiary. And so again, that's another duty that the executor, executrix must adhere to.
And I'm going to once again show everybody the personal record of, because this book has places where you would list all of that for the benefit of your executor or anyone that needed to take care of your affairs under a power of attorney in the event of an emergency.
And I also just want to point out now, Surrogate, because I've had a couple of questions about where do they get the book. So you can get the booklet by sending an email to surrogate@co.morris.nj.us, or you can go to the Surrogate's website, www.morrissurrogate.com, and you can download the booklet and have it in hard copy.
Or the Records and Administration building here in the county is still open, and we have them in various kiosks around the building, or you can come to our office and request one.
Another question is, how do you handle multiple state assets? So if somebody has assets across other states.
Well, you contact that institution. All depends. You might have to do a filing in that state. I have one now in Montana that the person has a property in, and we have to exemplify copies of the surrogates proceedings from Hudson County and the Montana court, the county court of the jurisdiction, and they will accept that. It's been properly probated in New Jersey, and this person has the right to administrate the estate in Montana. So, it's exemplary proceedings. And that's, I think, the most I can tell you, depending upon what the asset is. This happens to be land in Montana. It could be different for financial institution. They will want to probably see a surrogate certificate, death certificate, and there might be some implication of estate tax.
And it's very common, New Jersey, Florida, New York, Florida,
Correct.
things like that. Even Pennsylvania, where people have weekend cabins.
So let's go back to the executor commission for a second. Is it a set standard amount that an executor receives, or can the testator designate what they would like the executor to receive?
They receive a minimum of the statutory commission. The executor could designate a certain amount to that person as a beneficiary on top of it, saying that this is additional funds that will be given to my executor as a beneficiary in reference to the daunting task, or just generically. You could give it without reference to any executor fee.
So someone's asking if all beneficiaries be removed from the bank accounts, mutual funds, and the like to allow the terms of the will to be carried out. So in other words, they're saying, but I think that you're required to put a beneficiary on those.
Right. I mean, not necessarily bank accounts. You could change the type of account so that it would go and be passed under the will. But as far as annuities and things like that, some will allow a trust to be a beneficiary, and it could refer to a testamentary trust as the beneficiary. Some will not even allow that unless there's an actual EIN number established for the trust. But definitely annuities and other instruments require a designated beneficiary.
And it's important to note that designated beneficiary predeceases the testator, and there's no secondary beneficiary, then it will lapse to the estate itself.
Right.
So it's also important to keep that booklet updated as to your assets and your beneficiaries.
Very important. Right. You don't want to get that booklet that I've been showing you and have it be outdated, and you've updated your will 10 times in the meantime, but never updated the booklet, because you've got another set of problems at that point.
And one thing good about the booklet is a lot of times you can't find the will until it's sometime later, but you're able to find that booklet, and the booklet's a great roadmap.
Yes. Okay, can I write my own will as long as it is notarized and signed by witnesses?
You can. Not recommended, but you can.
Then a will might become subject to litigation, and it all depends how you write that will, because a court cannot reform a will. They can only try to interpret the clauses of the will.
And it won't be a self-proving will.
Correct. Correct.
Another one came in about a holographic will. They're not sure exactly what that means. And you had said something about it goes to court.
Well, that's in handwriting. It's in the testator's handwriting, and it's typically that I leave everything to my spouse on a cocktail napkin as the plane's crashing toward the earth. It's something that's written very quickly when you have no alternative and there's exigent circumstances. It's not something that should be used as a formal will, and it will go to court. The only way that it can be probated is if it goes to court, because there's a presumption of invalidity that comes with that, based on the fact that there's no witness, there's no notary. Anyone that could mimic your handwriting could draft that at any time and submit it as your will for their own benefit. And that's something that we try to avoid happening here.
Okay, so what should an executor know about my will? Should a will be reviewed with an executor so they clearly understand what the contents is and your wishes are?
Want to take that, Chip?
I would not recommend that. But I do recommend that if you name somebody an executor or executrix, that you tell them that you have made a will and maybe where you have been placed in that will. I don't really think that you should put a will in the safety deposit box, because it's a little difficult to gain entry to that safety deposit box unless you're a co-signer with the bank. So no, I wouldn't recommend reviewing my will with a beneficiary or executor in the will. I would just tell the executor, executrix, that I've named you in it, because believe it or not, sometimes they say, thank you so much, but I really don't want that burden. I've done it before, and it was a little bit too taxing to me, and so.
So you really should ask an executor or an executrix to be that prior to just naming them.
If you can, if you want. I mean, that's a really personal decision.
If you have a number of siblings and they don't necessarily get along well, it can become very, very contentious, subject to challenge after challenge. The executor has to do a formal accounting if anyone requests it and submit it to this office. We then review it. It goes back and forth many times with many questions. It gets very complicated. You end up employing accountants and advisors. Oftentimes an executor may end up with their own attorney to help them in a challenge with the siblings or with any beneficiary. So it's not always a simple procedure. People think that, well, because of the will lists the amount, but everybody will contest. Let's say the parents had a house, and now what is the value of the house? Well, you let the house sit vacant and the pipes burst and you had to spend that money on repair. And if you had been on top of it, that wouldn't have happened. If you sold it fast enough, we would have had to pay for the new roof. You should pay for that. And all the way down to I've seen there was a mixing bowl, and no one was a baker, no one cared about the mixing bowl, but the whole family wanted to make this particular mixing bowl because they thought it was the most valuable item in the basement. Then the whole family wanted a cap gun because each one of them had special memories associated with this cap gun. So that was another fight. And it really at times can be a tedious, daunting, and very lengthy task. It can go on for years.
Okay, so this next question really, I think, needs a little bit of clarification. Somebody writes, the booklet is not an official document like the notarized will ? So we might want to say that the booklet was created as a roadmap in case of an emergency or should someone pass away. And it really is for the family and the friends so that they know where things are located. And it really is a thinking process that you can go through to prepare to do your will, because it gets you through all your assets and identifies things. And it recommends that you state where your passwords are. You don't necessarily have to write them in the book. It really is a roadmap, and it tells people where to find things. Heather, do you want to add to that?
No, I mean, that's a very accurate representation of what it is. The book, when you start to think about gathering your information, that is tedious. And the book is a roadmap to any individual on what that information might be that you need to gather and include. So before you go to an attorney to have your will prepared, if you have completed this booklet, it will make it much easier for you to have the conversation that you're going to need to have with the attorney. By no means is the booklet an official document. It is simply a guide that, one, helps you prepare a will, and two, helps anybody that may be looking at whether it's your will, your living will, your power of attorney, and utilizing that for whatever circumstance is going on in your life at the time to better enable them and make it easier for them to do the job that they're setting forth on.
Correct. And it even goes so far as to ask if you have pets, who should care for the pets while you're either in the hospital or. Okay. If you do not have the option to have an executor, can you assign a bank as your executor?
John?
Yes, quite often the bank is the executor of a will. Correct. And sometimes they name a person in the bank, but again, that person hopefully is still employed by that bank. If not, then you have to find that person. But I have one right now where a bank is the executor of the estate.
Okay, do you have to have a contract with a bank prior to naming them as an executor?
No.
They'll receive a fee for doing this. So based on the fee that they're receiving for doing this, they're typically willing to act as executor.
And don't forget that the bank will hire the estate attorney at that point. So the bank itself, while they might be the executor, they will turn it over to an attorney and maybe an accountant to handle the affairs of the estate.
And to the point that John just made, you are permitted as the executor to hire experts as needed to assist you in this regard. So that is highly recommended if it's a sizable and complex estate.
What about online wills?
I'm sorry, what was that question?
Online wills, do you think that that is a tool that is useful and legal?
You might legal Zoom wills or?
Yeah, that kind of, you can find, forms for wills online. The question is, what about online wills?
I recommend against, and the reason I recommend against is because there are things that an experienced scrivener, the drafter, the attorney is going to recognize in conversation. They're going to know if you say certain keywords, there's other questions that they need to ask now to drill down on that. And it's not a simple fill in the blank. And also, if I get an online will, how that will is executed is not likely to be in accordance with the law, especially with the self-proving law where everyone has to sign in the same room at the same time, so that everyone can attest to the fact that those signatures are original. And the document itself is called self-proving because that's an ironclad document. If I get it off the internet, how do I, what is the likelihood that while I'm looking for that kind of modern convenience, I'm going to get all these people in a room together and do this at the same time? It's slim to none. I'm probably going to sign it as the testator, then I'm going to take it over to my friend Bob when I see him at the gym, and he's going to sign it there, and so on and so forth. And then ultimately I'll run to a notary at the bank who can't notarize it because they didn't witness the other signatures. So there's a presumption of invalidity unless you do everything properly that you're not likely to with that. I don't know if you have anything you want to add to that, John.
No, I'm not a big proponent of online, documents as to wills or living wills and power of attorneys, especially because I think power of attorneys now are being questioned more and more, especially by financial institutions.
Okay, you had talked about standing when filing a caveat. Can you explain what standing means?
Standing is a court term, and what it means is that you have a right to bring that case. So for example, let's say that John came in to probate a will here in the office. He was listed as the executor under the will. And all of a sudden, some guy that happened to be walking down Washington Street decided that he was going to come in and file a caveat to challenge this will. And he knew to do that because he overheard John having a conversation with somebody standing on the sidewalk before John walked in the door, saying he was coming in to probate a will for Mr. X. The guy on the sidewalk doesn't have standing unless he's a beneficiary or would be an heir under the laws of intestacy if that will were invalid. You need to show that you have some sort of right or entitlement to something in that will in order to have standing.
Okay.
John, if you want to clarify that, because that might have been a little technical.
No, I think that was pretty on point, that you have to have some type of relationship to that person in order to attack the validity of the will. And when you attack the validity of a will, it has to be by clear, convincing evidence to overturn the will itself. So that's a very heavy burden.
Right, just having standing to file a caveat doesn't mean it's successful. It means that you have standing to make the challenge, and that's it. So from there, the case will go to Superior Court, and the judge will determine whether or not you have that right. And in some cases, it happens.
Okay, I think we have time for one more question. If a spouse dies without a will, does the other spouse automatically inherit or get all of their assets? Because do they have to be co-owner? What?
Well, it depends how the assets are held. If it's their their residency, and it's husband and wife by tenants by their entirety, it automatically goes to the surviving spouse. If not, then you look at the statutory scheme, and the wife, depending upon the estate value, gets 1/3 of her aggregate share of the estate. You have to look at the bigger picture. If there's children involved, and then there's a percentage breakdown according to the statute.
Also surviving parents.
Surviving parents too, yes, because now we're living in an age where your parents might outlive you, and then it's an upward mobility percentage also. I think they're entitled to a sum of money. It's all based upon the value of the estate, though.
Okay, I'm going to get ready to turn this back over to the surrogate, but I'm telling everyone I'm sending the email address out on chat, so you'll have the email if you'd like to get the booklet, and I'll also put our website.
Christine, could I just say one more thing, since we mentioned that grandparents and people are living older and older nowadays. A lot of people come to my office and they're older than they want to be, but they want to make this will. And what I've been doing lately, I've been videotaping people when they make their will, and the signing process also. In the event that there is a caveat filed, or there's an action filed against the will for undue influence, or the person was incapacitated, all allegations, but the videotape proves it true that this was the person's intent. And as I say, why you want to have a will, you want to have a will because there's a last opportunity you get to speak to your loved ones when you're no longer here. So you're setting forth your intentions and your wishes. Would you agree on that, Judge?
Great sentiment.
And maybe one more question. How does one find an attorney that will be able to help them and quickly to get a will done?
Well, the Morris County Bar has a lawyer's referral service that we recommend too. Of course, you can always talk to family and friends that are happy and get a referral from them. We in this office are not allowed to refer attorneys.
Okay, surrogate, I'm going to hand it over to you for ending.
All right, Christina, thank you. Great job as always. John, thank you for coming on and for being our guest today. Thank you for some very great advice that you've given. And thanks to everyone who joined our program today. I hope you stuck through to the end, because some of the questions gave us an opportunity to talk about some things we didn't address during the program that were very relevant. So thank you all for the very thoughtful questions. And we hope to see you at future surrogate sessions.
Thank you, Judge.
Thanks, John.
Okay, have a good day, everyone.
You too, Christina.